There is a 30-minute phone call buried deep inside these court filings, and that single call explains nearly everything about this case. It was not secretive. It was not unusual. It was a standard vetting conversation. And yet, the moment attention shifted to that call, everything spiraled. Sanctions were demanded. Objections turned into headlines. Suddenly, the process itself was treated as something dangerous. That reaction is the real story. Because what many people keep overlooking is this: the public, for the most part, has already made up its mind about who they believe is right here. That is not speculation. There is a TMZ poll connected to this dispute, and the results are unmistakable. People have seen the filings. They have watched the clips. They have observed the behavior. An opinion has already settled in. That matters not because public polls decide legal outcomes, but because everyone involved knows the tide of perception has shifted. Once that happens, behavior changes. Arguments stop being about facts and start being about damage control. That is where this case currently sits. People are no longer watching to see who wins. They are watching to see who can remain still when the spotlight turns harsh. Once positions harden and the record is fixed, persuasion stops being the goal. The case becomes a pressure test. Can you tolerate resistance without escalating it? Can you allow a process to move forward without narrating every emotional moment? Can you accept that not every development favors you? That is where this case changed, not legally, but behaviorally. And the documents make that shift clearer than any press statement ever could. At the center of this is an expert named Nicole Alexander, and her role is critical. She was hired for a very specific purpose: to analyze whether the online backlash Blake experienced was the result of a coordinated smear campaign or whether it was organic public reaction amplified by normal media cycles. That distinction is everything. If the backlash was organic, Blake's core narrative weakens. If it was manipulated, her framing holds. This expert was not a side figure. She represented a structural risk, which is why her deposition mattered. During that deposition, she testified to something completely routine. Before being retained, she participated in a 30-minute call in August as part of a vetting process. She had not yet been hired. She was one of several candidates under consideration. She described the call exactly as anyone in her position would: normal, uneventful, industry standard. That is precisely why what followed raised eyebrows. The moment Blake's attorneys began shifting away from the expert's analysis and toward how she was recruited, the defense drew a narrow line. They instructed the witness not to answer questions that moved from methodology into motive, citing privilege in a limited and consistent way. That is a routine step in expert depositions. What was not routine was the response. Instead of noting the objection and moving on, Blake's team treated that boundary as a crisis. A standard limitation was reframed as misconduct. A normal privilege line became the centerpiece of a sanctions motion. That is where things stopped looking procedural and started revealing who was uncomfortable losing control of the narrative. To anyone watching without a law degree, a different set of questions naturally arises. Why was Blake's side so focused on how the expert was recruited rather than what the expert actually concluded? Why did motive suddenly matter more than methodology? And why did a routine objection trigger such an outsized reaction? This is where the pattern becomes clear. Blake's team is not responding to legal danger. They are responding to narrative discomfort. Whenever something happens that they cannot fully control, the response is not patience, it is intervention. A deposition becomes tense, which is normal. Instead of moving forward, it becomes a crisis. An expert does not affirm the preferred storyline. Instead of rebutting the substance later, the questioning itself becomes the problem. A routine procedural moment occurs, and suddenly it is framed as a moral emergency requiring immediate court involvement. That is not confidence. That is an intolerance for uncertainty. Now compare that with the other side. Baldoni's team is boring, painfully boring. And that is exactly why it is working. In an industry addicted to chaos, the people who refuse to manage emotions publicly often become the safest presence in the room. They show up. They answer questions. They let the record develop, even when it is uncomfortable. They do not ask the judge to referee feelings. They do not pause proceedings to litigate tone. They allow things to remain dull. Blake's team, by contrast, cannot stop explaining itself. Every pushback needs framing. Every moment of discomfort requires context. Every unanswered question feels like something that must be corrected immediately. At some point, that stops reading as advocacy and starts reading as self-soothing. This is where the defense lands its quietest but hardest blow. They note that Blake's team sat through a 7-hour deposition, allowed it to conclude, did not seek real-time court intervention, and only afterward filed a sanctions motion based on selected excerpts. That timing matters. It shows this was not about fairness in the moment. It was about optics afterward. In other words, the issue was not what happened, it was how it might look. That is why the defense openly accuses Blake's team of filing the motion to generate headlines. That is not a casual claim. It is a deliberate one. Zooming out, the pattern is impossible to miss. This case is not only being litigated in court, it is being managed emotionally. The expert was not there to comfort anyone or validate a story. She was there to analyze data. When that analysis did not cooperate, control became the priority. That is why recruitment questions mattered so much. Once you question how an expert was chosen, you imply bias. And once you imply bias, you can avoid engaging with conclusions. It is a familiar tactic, and it leads straight into the central irony of this case. The side arguing that public perception was unfairly shaped outside the courtroom cannot tolerate perception operating independently inside it. Questions become off-limits. Discomfort becomes misconduct. Confusion becomes sanctionable. That is not about protecting the process. It is about protecting the story. Judges do not exist for that. They exist to decide whether the process itself is broken. Here, the judge reviewed the record, found it was not, and told everyone to move on. That was not dismissal. It was a boundary, and boundaries tend to frustrate people who are used to steering the narrative at all times. So when people ask why this case feels like it keeps dragging, the answer is not legal. It is behavioral. One side is willing to sit in discomfort and let time and transcripts do the work. The other keeps interrupting to explain why the experience feels unfair. That is why this case does not feel explosive. It feels exhausting. And exhaustion is the one thing Hollywood avoids more than controversy. So no, this is not about who objected louder. It is about what this case is quietly exposing. When your story is strong, you let it stand. When it is fragile, you hover. Baldoni's team is letting the record speak, even when it is not flattering. Blake's team keeps stepping in to manage perception moment by moment, question by question. That's how the record reads to me.